Hello everyone, welcome back. Today we are discussing the fifth chapter from Business Laws and Ethics, that is Indian Partnership Act 1932. In this session, we will be learning the meaning or the definition of partnership, the essential elements, the different types of partnership, the types of partners, etc. So let's get started with the meaning and definition of partnership. So, partnership is a business relationship where two or more persons come together to conduct a lawful business and share their profits. So, according to Section 4 of Indian Partnership Act 1932, partnership is the relation between persons who have agreed to share the profits of a company carried on by all or any one of them acting for all. From this definition, we can identify some important points. There must be an agreement, there must be a business, profit should be shared, and mutual agency must exist. The persons are called partners and collectively called a firm, and the business name is known as the firm name. Now let's move on to the next topic, that is essential ingredients of partnership. The first element is agreement between persons. Partnership always arises through agreement. It may be oral or written. At least two persons are necessary. The second one is business. The agreement should relate to a lawful business activity such as trade, profession, or occupation. The third is sharing of profits. The partners should agree to share profits of the business. The fourth and the most important element is mutual agency. This means that the business can be carried on by all or any one partner acting on behalf of all others. So every partner acts both as a principal and as an agent. The next topic is types of partnership. The first one is general partnership. In this type, all partners participate in management and their liability is unlimited. The second one is limited partnership. Here, some partners have limited liability restricted to their capital contribution. The third type of partnership is partnership at will under Section 7. So, if there is no fixed duration and no condition regarding termination, it is called partnership at will. Any partner may dissolve it by giving notice. The fourth one is particular partnership. This partnership is formed for specific purpose or project. Once the work is completed, the partnership comes to an end. Now let's move on to the next topic, that is types of partners. So first one is working or active partner. This partner actively participates in management and daily business activities. The second one is sleeping or dormant partner. Such a partner contributes capital but does not participate actively in the business. The third is secret partner. Here the person participates in business but his identity is not disclosed to outsiders. The fourth is limited partner. Liability is limited to the agreed contribution. The fifth is partner in profits only. This partner shares only profits and generally does not bear losses internally. The sixth type of partner is nominal or ostensible partner. This partner only lends his name to the firm and becomes liable to outsiders. Finally, minor as a partner. Here under Section 30, a minor cannot become a full partner but may be admitted to the benefits of partnership with the consent of all the partners. Now let's move on to the next topic, that is partnership is a creation of contract under Section 5. So Section 5 states that partnership arises from contract and not from status. This means partnership cannot arise by birth or family relationship. For example, in a Hindu undivided family, membership comes by birth, but partnership requires agreement. The next topic is difference between partnership and company. Now let's compare partnership and company. A partnership firm does not have a separate legal entity, whereas a company has separate legal existence. In partnership, the liability of the partners is unlimited, but in a company, the liability is limited. Partners manage the business directly, while companies are managed by directors. The transfer of ownership is restricted in case of partnership but freely transferable in case of companies. Also, the statutory audit is compulsory for the company, but for the partnership, there is no compulsory. In case of partnership, the dissolution can be made much easier, but in case of a company, there are certain legal processes to be done. Now let's move on to the next topic, that is difference between partnership and LLP. So limited liability partnership has separate legal entity and limited liability, whereas ordinary partnership does not. So LLP can enter into contracts in its own name, as well as the LLP has more legal compliances as compared to the ordinary partnership. Now let's move on to the next topic, that is difference between partnership and HUF. So the partnership arises through agreement, while Hindu undivided family arises by status or birth. In partnership, all partners may manage the business, but in HUF only the Karta, that is the senior most person, manages the business. The profit sharing in partnership depends on the agreement, whereas in Hindu undivided family it depends on the Hindu law. So the dissolution is done in partnership by agreement or law, and in case of HUF it is done by partition. Now let's move on to the next topic, that is rights and liabilities of partners. First one is duties of partners under section 9. So according to this section, partners are bound to carry on the business for greatest common advantage, to act honestly and faithfully, and to provide true accounts and full information. The first duty is duty to work for common advantage. This means every partner should work for the benefit of the firm and not for the personal interest. The second one is duty of good faith. Partners should maintain honesty and trust among themselves. The third is to render true accounts. Every partner must maintain transparency regarding financial matters. And the fourth one is duty to provide full information. Partners should disclose all important facts affecting the business. The next topic is rights and duties of partners under section 11, subsection 1. This section states that mutual rights and duties of partners are determined by agreement between the partners. The agreement may be express, that is meaning written or spoken, or implied from the conduct. So partners may modify their rights and duties through mutual consent. Next one is agreements in restraint of trade. Generally, agreements restraining trade are void, but the Partnership Act provides certain exceptions. Under section 11, subsection 2, a partner may agree not to carry on competing business during partnership. Under section 36, subsection 2, an outgoing partner may agree not to compete after retirement within reasonable rights. Under section 54, after dissolution, partners may agree not to carry on similar business within certain local limits. And when goodwill is sold, the seller may agree not to carry on competing business. These restrictions are valid if reasonable. Now let's move on to the next topic, that is conduct of business under section 12. This section provides certain rights to partners subject to agreement. First, every partner has right to participate in the business. Second, right to be consulted in business matters. That is, partners have the right to be consulted in business matters. The third is ordinary matters are decided by the majority. So, however, change in nature of business requires unanimous consent of all partners. Finally, every partner has the right to inspect and copy books of accounts. Now let's move on to the next topic, that is mutual rights and liabilities under section 13. So first, partners share profits equally unless otherwise agreed. Second, partners are entitled to salary for participating in the business. Third, the interest on capital is not allowed unless agreed. The fourth is, if a partner gives advances beyond capital, he is entitled to get 6% interest. Fifth one is that the firm must indemnify partners for expenses incurred in ordinary course of the business. Now let's move on to the next topic, that is rights and duties after change under section 17. This section applies when changes occur in partnership. The first case is change in constitution of firm. If a partner enters or retires, the old rights and duties continues unless changed by agreement. Second, if a partnership formed for fixed period continues after expiry, the same rights and duties continue. Third, the partnership formed for a specific adventure continues after completion. Again, the same rights and duties continues. Next, let's move on to the next topic, that is partner as agent under section 18. This means act done by one partner in ordinary course of business bind the entire firm. So, every partner is an agent of the firm. Next topic is implied authority, sections 19 and 22. So, implied authority means authority of a partner to act on behalf of the firm in ordinary course of business. For example, purchasing goods, receiving payments, or signing contracts. However, implied authority does not allow a partner to submit dispute to arbitration or open a bank account in personal name or to transfer immovable property or enter partnership on behalf of the firm. Such act requires special authority. The next topic is extension and restriction under section 20. So under section 20, partners may extend or restrict implied authority by agreement, but restrictions affect outsiders only if outsiders know about them. The next topic is authority in emergency under section 21. In emergency situations, a partner may take necessary actions to protect the firm from the loss. Such acts are binding on the firm. Next one is effect of admission under section 23. The admissions or statements made by a partner regarding the firm affairs become the evidence against the firm. Next one is effect of notice under section 24. Notice given to an acting partner is treated as notice to the firm itself. However, this rule does not apply in case of fraud committed by the partner. Now let's move on to the next topic, that is liability of partner under section 25. Section 25 states that every partner is jointly liable for the acts of the firm. Even after death, the estate of deceased partner remains liable for acts done while he was a partner. Next one is liability of firm under section 26 and 27. Section 26 provides that the firm is liable for wrongful acts committed by partners during ordinary business, and 27 deals with misapplication of money or property. The firm becomes liable in two situations: when a partner receives money from third party and misuses it, or when the firm receives money and a partner misappropriates it. The next topic is holding out under section 28. If a person represents himself as partner or knowingly allows others to represent him as partner, he becomes liable to third parties. This is called partner by estoppel or holding out. Next topic is rights of transferee under section 29. A partner may transfer his interest in the firm, but the transferee does not become a partner. The transferee cannot interfere in the management, cannot inspect the books, and cannot demand accounts. He is only entitled to receive the transferred share of profit. The next one is minor as partner under section 30. A minor cannot become a full partner but may be admitted to benefits of partnership. A minor has the right to share profits, inspect accounts, and sue for his share. His liability is limited only to his share in the firm. On attaining majority, within 6 months, the minor must decide whether to become a partner and give public notice. The next topic is rights of outgoing partner under section 37. Finally, section 37 deals with rights of outgoing partner. If the outgoing partner's share is used after retirement or death without settlement, he may claim either share of profits attributable to his share or interest at 6% per annum. The next topic is determining existence of partnership under section 6. So here let's understand how to determine whether partnership exists. Section 6 states that the real partnership between parties should be considered and not merely the name given to it. The most important test is mutual agency. This means whether a person can act on behalf of others and whether he acts bind the firm. If mutual agency exists, partnership exists. The next one is receipt of share in profits. Now, receiving share in profits alone does not make a person a partner. For example, an employee receiving commission based on profits, a widow receiving annuity from profits, or a lender receiving interest linked with profits are not considered partners merely because they receive profits. The next topic is partnership at will under section 7. Partnership at will exists when no fixed period is mentioned and there is no provision regarding termination. Any partner may dissolve such partnership by giving notice. Next one is particular partnership under section 8. It is formed for specific project, adventure or undertaking. Once the purpose is completed, the partnership automatically ends. The next topic is property of firm under section 14. So it includes assets introduced by the partners, assets acquired during the business and the goodwill of the firm. The next topic is application of firm property under section 15. The firm property should be used exclusively for business purposes according to agreement among other partners. Next one is formation of partnership. Now let's discuss the formation of partnership. The first essential ingredient is agreement between partners. Second, there must be lawful business. Third, there must be sharing of profits. And the fourth one is, the most important one, is mutual agency. Now, the procedure of forming partnership includes selecting the partners, choosing firm name, preparing partnership deed, deciding capital contribution and profit sharing ratio, and registration if desired. The next topic is reconstitution of firm. Reconstitution means change in relationship among partners without complete dissolution of the firm. It may happen in different situations. So now let's see the different occasions of reconstitution. The first one is change in profit sharing ratio. Partners may mutually decide to change profit sharing ratio. In accounting treatment, assets and liabilities are. Second one is admission of a new partner. A new partner can be admitted only with the consent of all existing partners. So after admission, profit sharing ratio changes, sacrificing ratio is calculated and goodwill adjustment is required. So the accounting treatment includes revaluation account, goodwill treatment and capital adjustment. The third situation where reconstitution occurs is retirement of a partner. A partner may retire according to agreement with consent or by notice in partnership at will. The accounting treatment includes revaluation of assets and liabilities, goodwill adjustment and settlement of retiring partner's capital account. Now let's move on to the next topic, that is liability of retiring partner. A retiring partner remains liable for the acts done before retirement. To avoid future liability, public notice of retirement must be given. Next topic is death of partner. Death of partner generally causes reconstitution of the firm unless otherwise agreed. Accounting treatment includes revaluation, goodwill adjustment and settlement with legal representatives. Next topic is liability of estate of deceased partner. The estate of deceased partner is liable only for obligations existing before death and not for future acts. The next topic is expulsion of partner under section 33. A partner may be expelled only according to agreement and in good faith. Next one is insolvency of partner under section 34. When a partner becomes insolvent, he ceases to be a partner from the date of adjudication. Next one is revocation of continuing guarantee. Under section 38, a continuing guarantee is revoked when there is change in constitution of the firm unless otherwise agreed. The next one is amalgamation of firms. Two partnerships firm may combine to form a new firm. Accounting treatment includes revaluation of assets and liabilities, the goodwill adjustment, transfer of reserves, and capital adjustments. Now let's move on to the registration of firms. Registration of partnership firms is optional but highly advisable because non-registration creates legal disabilities. Next topic is registrar of firms under section 57 and 58. The state government appoints registrar of firms. For registration, application should contain the firm name, the address, the details of partners and duration of partnership, and it must be signed and verified by the partners. The name of the firm should not be illegal as well as not misrepresent government patronage. Next one is alterations in registration. So changes in firm name, place of business or branches or partner details must be informed to registrar under section 60 to 63. Next topic is rectification and inspection. Registrar may correct clerical mistakes under section 64. The register of firms may be inspected by public upon payment of prescribed fees under section 66 and 67. Next one is rules of evidence. Certified copies issued by registrar are admissible as evidence under section 68. Now let's move on to the next topic, that is effect of non-registration under section 69. An unregistered firm cannot sue the third parties, enforce contractual rights or claim set off. However, third parties can still sue the firm. Next one is penalty and public notice. False information given to registrar attracts penalty under section 70. Public notice under section 72 is given through official gazette, newspapers, and a notice to registrar. The next topic is dissolution of firm. Now let's move on to dissolution of firm. Dissolution means termination of partnership relation among all partners. Now let's see the modes of dissolution. The first one is dissolution by agreement under section 40. A firm may be dissolved by mutual agreement among partners. Next one is compulsory dissolution under section 41. So compulsory dissolution occurs when business becomes unlawful or all partners becomes insolvent. The next one is dissolution on happening of contingencies under section 42. Dissolution may occur due to expiry of fixed period, completion of adventure, death of partner or insolvency. The next one is dissolution by notice under section 43. In partnership at will, any partner may dissolve the firm by giving written notice. The last one is dissolution by court. So under section 44, the court may dissolve the firm on grounds as insanity, permanent incapacity, misconduct, persistent breach of agreement, continuous losses, or just and equitable grounds. So here, just and equitable means a decision, settlement, or outcome. This is fair, reasonable, and morally right based on the specific circumstances rather than strictly by rigid legal rules. So it ensures that parties are treated properly, often balancing the contributions and future needs. The next topic is liability after dissolution under section 45. The partners continue to be liable to outsiders until public notice of dissolution is given. The next one is rights after dissolution, section 46. After dissolution, partners have the right to apply property for payment of debts and distribute remaining surplus. The next topic is continuing authority. Even after dissolution, partners retain authority for winding up affairs and completing pending transactions. The next one is mode of settlement under section 48. So the losses are first adjusted against the profit, then the capital, and finally partners personally. Assets are applied in this order. First the outside liabilities, then the partner loans, then the capital, and finally surplus among the partners are divided. The next topic is payment of firm's debt under section 49. Firm property is first used for payment of firm debts, while personal property is first used for personal debts. Personal profits after dissolution under Section 50. If a partner earns profits using firm's property after dissolution, those profits belong to the firm. Next one is return of premium under Section 51. If a partner paid premium for fixed term partnership and the firm dissolves before expiry, reasonable refund may be claimed. Now let's move on to the next topic, that is rescinding of contract under Section 52. First, let's understand the meaning of rescinding. Means cancelling the partnership agreement. A partnership contract may be cancelled when a partner entered into the agreement because of fraud or misrepresentation by another person. So, Section 52 mainly protects the innocent partner who suffered because of fraud or false representation. Now, let's see the provision. It states that when a contract creating partnership is rescinded on the ground of fraud or misrepresentation of any party, the partner who rescinds the contract gets certain rights. There are three main rights given under this section. First, the right of lien or retention. The innocent partner has a right to retain the surplus assets of the firm after all outside liabilities are paid. This right is available for the amount paid for purchase of share in the firm and the capital contributed by him. In simple words, the innocent partners can recover the money invested by him from the remaining assets of the firm. The second one is right to rank as a creditor. If the innocent partner has paid any debts of the firm, he can claim that amount as a creditor of the firm. That means he will be treated like an external creditor for the amount paid by him. The third right is right to indemnity. The innocent partner can claim compensation from the partner who committed fraud or misrepresentation. The guilty partner must indemnify the innocent partner against all debts of the firm. So the loss caused because of fraud should be borne by the guilty partner. Here we are concluding this chapter. Until next, keep learning and keep growing. Thank you.